Members, we now move to part 2, and this is debate on clauses 23 to 35, and the question is that part 2 stand part. I call Claire Curran.
Thank you, Mr. Chair. Part 2 of this bill is essentially updating and other pieces of legislation, amendments to acts concerning the use of digital communication. And they include the Crimes Act, the Harassment Act, the Human Rights Act and the Privacy Act. The first point that I'd like to make actually is to thank the Minister who gave us 10 minutes of her time earlier in part 1 to actually get up and give an explanation as to why she had introduced such a large set of amendments. The amendments that she's introduced in part 2 are essentially just additions, mainly technical points around those four acts that I've just mentioned. One of the points that I'd like to make is that with one of those acts, the Privacy Act, what would be really good is if the Minister followed this piece of legislation before the House with the introduction of the substantive changes to the Privacy Act itself, which have been promised to this House for well over a year, following a Law Commission report 4 years ago, and which make real changes to balance up the privacy provisions for New Zealanders, which have been lacking and for which the Law Commission has recommended that we act quickly on. Instead, what we've got here is as I think what we would say is that this is a worthy part of the Act, and I don't think that there was ever a great deal of dissension at the Select Committee on the need for these 4 pieces of legislation to be updated because they needed to be brought into the digital world to include provisions around electronic communication and essentially to be modernised. The argument that Labor used in the Select Committee, which has been supported out there in the community, particularly by the legal community, is that the updating of these 4 pieces of legislation could have been sufficient to address this issue, rather than by introducing particularly a new criminal provision, as we've discussed in part 1. Because the updating of the Crimes Act, the updating of the Harassment Act, and the updating of the Human Rights Act and the Privacy Act are all existing pieces of legislation that have been well tested and have been well utilised. And yes, they needed to be modernised, but they reflect what happens in the physical world. As well, and the updating of them was enabling them to also be relevant in the cyber world, in the digital environment, and as rightly so. But what is added to this piece of legislation is a new provision, a new criminal provision, which is only active in the cyber world, which is groundbreaking, you could call it precedent setting, and what it means is that acts of causing serious emotional distress that occur in the digital environment can only be prosecuted in the cyber environment under that provision. They can't be prosecuted in the physical environment. So even if there is an act of serious emotional distress that includes a physical act, then it's not relevant according to that particular provision. So we feel very strongly that the updating of these 4 pieces of legislation is necessary, because this is an important part of the move towards trying to be more effective in the cyber environment. But alongside this goes an educative role of the particularly the police, who's the agency that does the prosecuting, as to how effectively to use them. And it's our concern, Mr. Chair.
Clear, Karen.
It's our concern that this is going to be missing in the equation, and it's already been mentioned in previous speeches that the police currently have the discretion about whether they will prosecute. There's been numerous cases that have been before the public's attention about where there has been cyber bullying, cyber harm undertaken, and where there were already were already provisions that could have been utilised but weren't because there had not been the education of our police force around how to do that. And I think there's been a number of occasions when that has happened in recent months, and certainly in the last couple of years. But what our fear is that this bill, because of this new criminal provision in the cyber environment, that what this bill will do is that it will create pressure on police to prosecute children in a court environment when the police may not have had the training or the systems to decide when or not that's appropriate. And that is a real concern. And I think that one of the tests for this bill is just how well the educative function goes with it as to what is appropriate to take into the court environment and what is appropriate to take through the agency environment and the approved agency environment. We have, and there are many different kinds of cyber harm that can be caused, and when you're using legislation that already is proven and and where there's a lot of case law in place, such as the Harassment Act, such as the Crimes Act, then we should, our contention is that we should be moving more in that direction rather than using a new provision that's just been set up just for the cyber environment, and which has such a broad definition of harm attached to it, and where there are so many questions that remain around it as to whether it will be effective. Labor's introduced an SOP in this part under the Harassment Act. Which I actually don't have in front of me, but which is, I think, is at Part 17 of the existing Harassment Act, which is essentially to ensure that where there is material in the electronic communications that are being used and may be construed as being harassment, that where they don't break the law, that therefore that measure cannot be used. And this is basically taking a measure that's existing in the Harassment Act now and ensuring that that's updated to include the cyber environment as well. And so we consider that that's a practical measure, and we hope that there will be support across the House for that. As we've said in previous speeches on this bill, Labor is reluctantly supporting this bill through the committee stages of the House because we know that we need to take measures in the cyber environment. We believe that the approved agency route is a sensible route to go, although we've got concerns around the resourcing of that and whether it will be appropriately resourced. We have got serious concerns about other parts of the bill, but we do think that the updating in Part 2 of the bill of these 4 pieces of legislation is sensible and is probably overdue. However, our concerns are such that we do believe that there needs to be a review of this legislation after a period of time to ensure that it is actually effective and that our fears haven't come to bear. So Labor is putting on record today that we will be undertaking a review of this legislation and that will be our position.
Mr Chair.
I call Jacinda